Okay. Good afternoon. Good afternoon. It is just good afternoon, and apologies as we're running a little over time. But we will, just taking account of that, we aim to finish this session by 1:15 at the very latest. This is panel 2 on liberal abortion regimes, different models and options after reform. I'll be moderating it. My name is Ivana Bacik. I'm a senator here in the Irish Parliament, the Oireachtas. And I just want to welcome all the members from the international network here, and to thank Liam and the ICCL for hosting this very timely conference. It's very useful for any of us involved in the campaign, the pro-choice or repeal the ACE campaign. I know we had a conversation about language. Very important and very timely for us to be engaged in this as we face into a referendum in, we hope, in May of next year, May 2018 here in Ireland. And I listened earlier with great interest to the debate, and it's very good to hear the global perspective. But I was, as I think many of my Irish comrades will be would have been somewhat amused to hear about Francis talk about a backlash, because of course here in Ireland we haven't yet had a frontlash. So when you talk about a backlash, Francis, in many Western countries in particular, where the right is seeking to, and the conservative forces are seeking to restrict or row back on abortion laws, of course our experience in Ireland is that we haven't yet made the progress towards having abortion laws that are in any way facilitative. So that's our experience. So I'm particularly looking forward to this panel, where we're going to hear about how in other jurisdictions there has been progressive reform and what different models and options after reform have taken place. So without further ado, I'll introduce our first panelist. We've got 4 panelists. I'm very excited to hear from 4 very different jurisdictions or countries, and I'll introduce each in turn. They're each going to speak just for 10 minutes, so we will have time for Q&A at the end. So the first speaker is Claire Johnson, who is going to speak about the experience in Britain, and she's a senior assistant at Liberty UK, which is the equivalent of the ICCL there, where she undertakes research and communications work on human rights issues arising in Northern Ireland. And previously she worked in politics in Northern Ireland, and I know is still hugely involved in the campaign there for abortion rights in Northern Ireland, as well as here in the Republic. So Claire first.
Hi, so I'm here today representing Liberty from the UK. This panel is on liberal abortion regimes, but in reality, we're somewhere between this panel and the one just before us. Whilst Great Britain, that is England, Scotland and Wales, have a relatively liberal, although imperfect, abortion laws, Northern Ireland, which is part of the UK, has a virtual blanket ban on abortion, with no exception for rape or fetal abnormalities. From an international perspective, like the one we have here today, this can be difficult to understand. From a domestic perspective, it's still hard to understand. It makes very little sense. As a result, Northern Ireland is often forgotten about in terms of the debate on abortion access, and I'll do my best today to explain the different legal frameworks in play, the context, and the possibility of change. Like many other countries, the 1960s was a period of social change in Britain, and this is the decade in which abortion was provided on the National Health Service under the 1967 Abortion Act. Prior to this landmark piece of legislation, abortion in Britain was governed by the 1861 Offences Against the Person Act, under which performing an abortion or trying to self-abort carried a maximum sentence of life imprisonment, and later the 1929 Infant Life Preservation Act, which created a new crime of killing a viable fetus, although the definition of this was unclear, in all cases except where the woman's life is at risk. They did not, of course, prevent unwanted pregnancy or the need for abortion, and in the decades before the 1960s, maternal death rates were at crisis levels. Thousands of women resorted to backstreet abortions, often permanently damaging their health or dying. According to the campaigning organisation Abortion Rights, between 1922 and 1932, 15% of maternal deaths were due to illegal abortion. This was the highest rate reached, but crisis levels continued well into the decades that followed. It was this public health emergency which served as the context and catalyst for abortion legalisation in Britain. The government proved hesitant to take on the issue of abortion, so the 1967 Abortion Act took the form of a private member's bill which legalised abortions by providing a defence to the 1861 Offences Against the Person Act in the following circumstances. where two doctors can verify that a pregnant person satisfies grounds A to E, and one doctor certifies grounds F or G are met in an emergency situation. According to statistics held by the Department for Health, 97% of abortions carried out in 2016 were under grounds C, and 99.8% of those were performed due to a risk to the woman's mental health. There has been no major reform of the 1967 Act since it was passed, bar the 1990 Human Fertilisation and Embryology Act, which changed the time limits for grounds C and D from 28 to 24 weeks and removed the time limits on grounds A, B and E. Those who campaigned for the Abortion Act in the 60s said that it was never expected to be the finished product, rather a starting point for further reform in 4 to 5 years' time. Instead, it has continued almost entirely unamended, while society and medical practice has progressed. We'll come back to this later. Although we don't have enough time to get into the history of Northern Ireland, the short answer to the first question is that at the time there was a devolved Parliament in Northern Ireland and Westminster didn't have the necessary legislative competence to extend it there. The second answer is unsurprisingly more complicated but important. Northern Ireland came into existence following the partition of Ireland in 1922. Today, Northern Ireland is a society emerging from 30 years of violent conflict, during which over 3,600 people died. As many as 50,000 were physically maimed or injured, and countless others were psychologically damaged. Northern Ireland remains a deeply divided society, and this has affected how social issues are viewed. Loyalties to the two largest parties, the Unionist DUP and the Nationalist Sinn Féin, remain tribal in nature, and voters tend to cast their vote for the party that supports their desire to stay in or to leave the United Kingdom. They fear that failure to do so will let the opposing party into power. This cycle of fear means that many voters feel they cannot vote on social issues in case this has a knock-on effect on the stability of Northern Ireland's union with Britain. Therefore, for these political parties, there is little impetus to advocate for social change. As I've mentioned, the 67 Abortion Act has never applied in Northern Ireland, and therefore abortion continues to be regulated by the 1861 Offences Against the Person Act and its maximum sentence of lifetime imprisonment. The Bourne judgment provides a defence to the 1861 Act in a very limited circumstances, where it's necessary to preserve the life of the woman or where there is a risk of real and adverse effect, either long-term or permanent, on a pregnant woman's physical or mental health if she continues with the pregnancy. Although there are some grounds for lawful abortions in Northern Ireland, they are very rarely performed. In 2015 to 16, just 16 abortions were carried out in Northern Ireland. This is due to a narrow interpretation of the existing law and confusion over official guidance for doctors, which resulted in a chill factor amongst medical practitioners. The lack of access to lawful abortions in Northern Ireland has meant that for generations, women have travelled to Britain, mainly England, to access abortions. Whilst recent changes have meant that this is now free of cost for low-income women, travelling is not an option for many. Women who do travel speak of the stigma and shame of being forced aboard a plane or boat just to access basic healthcare. Because of this stigma, it is hard to know how accurate statistics are. Some women will give the address of a friend or relative in England rather than their own, but at the very least, 2 women a day travel from Northern Ireland to Britain to obtain an abortion. It is worth noting that, that Northern Ireland is a small place with a population of 1.8 million, so in reality these numbers are proportionately larger than they may appear. The reason that these numbers appear to be decreasing over the past 5 years is due to the availability of abortifacient pills which can be bought online. These pills are used for abortions under 9 weeks of pregnancy and are on the World Health Organization's list of essential medicines for the developing world. They are also used in hospitals and abortion clinics, but are illegal throughout the UK when self-administered. The police in Northern Ireland have made seizures of these pills, and in 2015, a 21-year-old woman received a 3-month prison sentence, suspended for 2 years, for using the pills. In another case, a mother who helped her 15-year-old daughter procure abortion pills online has challenged the Public Prosecution Service on the decision to prosecute her. The girl found out she was pregnant in the summer of 2013 after a relationship with a boy older than her who she said was physically abusive. In written evidence submitted to court, her lawyer said the boyfriend threatened to kick the baby out of her and to stab it if it was born. The girl discussed her situation with her mother and considered whether she should keep the baby, give it up for adoption, or travel to England for an abortion. Her mother had heard that abortion pills were another option, and she read about them online. She knew they were safe to use, but not that it was illegal to use them. After taking the pills, the girl was upset and was being harassed by her ex-boyfriend. Her mother was concerned about her well-being and took her to her GP, where they spoke about taking the pills. A medical exam showed no ill effects and a referral was made for counselling. But 2 months later, a doctor told police that the girl had taken the pills. Neither the girl nor her mother were consulted about her records being handed to the police. I just wanted to highlight that one case as it illustrates the direct impact of the situation on women in Northern Ireland. The Northern Ireland Assembly has so far been reluctant to reform abortion laws, and the UK Parliament has neglected to take responsibility for what it sees as a devolved issue, even though that devolved institution has not been functioning for almost a year. In the absence of political action, this issue has fallen to the courts. The A and B case sought to highlight how, due to National Health Service regulations, women from Northern Ireland who travelled to England were actually barred from accessing abortions on the NHS. This was regarded as a non-emergency procedure which the pregnant person should have elected to take place locally in Northern Ireland, as would be the case with a routine procedure such as a tonsillectomy. The judgment disappointingly found in favour of the government, and I think Francis referred to that earlier, but the justices were split 3-2, and the very strong dissenting judgment later informed changes in policy in the same month. And that paved the way for a scheme to fund some Northern Irish women travelling to England to access abortions. Just last month, the Northern Ireland Human Rights Commission's case was heard in the Supreme Court. It centres on abortion access in cases of rape, incest or fetal abnormality, and argues that the current law in Northern Ireland breaches Articles 3, 8 and 14 of the European Convention on Human Rights. Thanks. Les Allenby, the Chief Commissioner, is speaking later today, so I'm sure he'll speak about that. As I've outlined in previous slides, the 1967 Abortion Act did not take abortion out of the criminal law. Rather, it made abortion legal when two doctors agreed a woman met certain criteria. Today, any woman who ends a pregnancy without that permission can still go to prison for life, and increasing numbers of women are illegally using pills bought online. It is also worth pointing out that whilst I mentioned earlier the arrests and prosecutions in Northern Ireland, police forces in England, Scotland and Wales do not seem to pursue those receiving pills through the post with the same vigour as the police service of Northern Ireland does. This is especially problematic given the lack of legal alternatives there. There's a consensus amongst proponents of decriminalisation that society has changed enormously since the 1967 Act, and that this should be reflected in updated legislation which gives a greater recognition of female bodily autonomy and which does not criminalise women for making choices over their own bodies. However, there is no singular understanding of what exactly decriminalisation means. Removing abortion from the criminal law entirely and relying on regulation, or preserving certain elements in the criminal law. And devolution means that decriminalisation would also take on different forms in each legislature, which is an added complication for the campaign. Decriminalisation seems to be almost within reach for England and Wales, but debate on the issue frequently fails to account for Northern Ireland, which cannot even use the 1967 Act as a starting point to contemplate further reform. In the interim, we have a part of the UK which has abortion laws that predate both female enfranchisement and international human rights standards. Just last month marked 50 years since the Abortion Act was passed in Parliament. And Liberty took the opportunity at our Human Rights Awards to honour all those involved in the movement for abortion rights in Northern Ireland for their tireless and multi-generational campaigning. Campaigners are very much hoping that the fight will be won in the next 50 years.
Thanks, Claire, for finishing on what I think was a positive note, or not. The next country we're going to hear about is South Africa. We're delighted to have Bongiwe Gumede, who's the Equality and Non-Discrimination Researcher with South Africa's Legal Resource Centre, working in Johannesburg. And she previously worked as a researcher with the trade union movement. So, Bongiwe, I don't know if you wish to speak from here or... OK, great.
Okay, I don't know if this works or not. Can you hear me? Yes. Okay. As been introduced, I am Bongiwe Gumede from South Africa. I work in the Constitutional Litigation Unit of the Legal Resources Center. Now, I would have liked to give you a bigger picture of abortion in South Africa, but due to time constraints, I'll just snap it a little bit. All right. So South Africa has had 2 laws pertaining to abortion. It was the 1975 Sterilization and Abortion Act and the Choice on Termination of Pregnancy Act, which I'll refer to as CTOP because the title is rather long. So according to the CTOP has had 2 amendments in 2004 and in 2008. So according to the CTOP, a woman can have an abortion up to 12 weeks. She can request the abortion, and it can be conducted by a medical practitioner or a registered nurse or registered midwife who has undergone the training. So that's up to 12 weeks. From 13 weeks up until 20 weeks, the abortion can happen only by a medical practitioner after consulting with the pregnant woman, and he or she, the practitioner, is of the opinion that the continued pregnancy will have it will result in a mental or physical injury to the woman. It will result in a physical or mental injury to the fetus. If it is a result of rape or incest, or if there is proof that in some way the continued pregnancy will have a disadvantage to the woman's socioeconomic standing. So that is from 13 to 20 weeks. And then from 20 weeks upwards, it is only done by a medical practitioner who has consulted another medical practitioner or a registered midwife or nurse, and they are of the opinion that a continued pregnancy will injure the fetus. It will result in a malformation of the fetus, or if it will in some way harm the woman who is pregnant. Now, in South Africa, the CTOP is much more, it has less restrictions than the first law that looked at termination. However, it still has certain limitations in terms of it being actually implemented. Firstly, the challenges, it is access to safe and legal terminations is restricted by designation. Now, the law clearly states that a termination of pregnancy can only happen in a designated area, designated medical facility, and that this designation is only given by the member of executive council. In this case, then, a hospital will have to apply in writing that they want to have the right to perform terminations of pregnancy, and there's a list of 10 requirements that each facility needs to have in order for this to happen. Now, the first part we're looking at is that of designation, in that if a medical practitioner is found to be performing terminations of pregnancy, they can be imprisoned for no less, it doesn't actually give a maximum, so it's more like, they say it's no less than 10 years if a medical practitioner goes through with this. One of our problems is South Africa in that we do not have a clear database that tells us where the designated facilities are and how many. So our National Department of Health has told us that there are 505 designated facilities in the entire country that can perform terminations of pregnancy. They cannot pinpoint where exactly these facilities are. So in a research that was done by Amnesty International, that's when they came up with the number of 505, which they can neither confirm nor deny. So one of our strategies then is to use litigation and to use advocacy. So the Sexual Reproductive Justice Coalition, which the LRC is part of, will then use litigation in order to sort of push government towards letting us know where the areas are. So the first one is that we're in the process of applying for an access to information submission. So what this does is that it forces, force may be a strong word, it encourages government to then do research into saying, where are the facilities, where are they located? And our point in doing this is to firstly then give women information on where these facilities are. Because in most cases you find that in rural areas, women do not firstly have access to this. They also do not have access to information as to the fact that if you are up to 12 weeks, you can request for the termination. They do not have to ask you why, the reason that you're getting this termination. So one of our plans then is for the access of information, is to get that information, and also to look at then, since the Act was passed, since 1996, 20 years after, has there been a progression or regression in the number of facilities that have been designated? And we plan then to use this information not only to inform the women of the places that are available, but also, since the Act states that reproductive health is part of our Constitution, it is part of what the Act is trying to do and encouraging choice for women, we will then use this information to say that they are failing in some way to look after the interests of women. Access to these, like I said, in rural areas, you find that a hospital is 100 kilometers away or so. So if women need to go and get a termination, they do not have access to these facilities. And in most cases, it is it is seen as a service that is only available to the rich, which, considering South Africa, is not a lot of individuals. When we talk about illegal abortions as well, like I mentioned earlier, that the area needs to be designated. So in most cases, we are aware of certain doctors who are qualified and able and willing to perform terminations. But since the MEC has not given them designation, if they do the termination, it is considered illegal and they can be arrested. And in most cases, this is what is being used by certain officials to say that if you make too much noise on the fact that there's not enough designation, we will bring up to the fact that you've been conducting CTOPs without they having been designated. So we'd rather look at designation, look at how well the designation is being issued out, look at whether there are certain protocols in place that will foster for the designation to go quicker and more efficiently, than rather to look at the Act itself, because South Africa's political circumstance at this point is that we do not want to open the Act up. We would rather say, okay, all the provisions that are done under the Act, let them be done efficiently so that the poor women in rural and villages of South Africa can actually access this. And then we also have an issue of backstreet abortion. So in South Africa, you have lamps and posts in the streets that will have someone saying, quick, easy abortions, 5 minutes. So in most cases, since women do not have enough information on where they can get abortions and the stigma around abortions, they actually will go to this clinic, and many women lose their lives because of this. So that is part of our point of saying that once we have access to the information as to which facilities can terminate pregnancies, more women can know that this is where they can go. And if you're up to 12 weeks, you do not have to give a reason as to why you want the termination to happen. So currently, just to end off, just to look at time, there are continued efforts to, there's been a private member's bill that has been put in front of Parliament that wants to, it's stipulating that in order for the termination of pregnancy to happen, the woman would have to first have an ultrasound, and they would have to get then a picture of basically the fetus. Now, in a situation like South Africa, where we literally have little resources to begin with, to force a woman to firstly say, they first have to find the equipment in order to do this, and that will prolong her gestation period. So many of civil society is actually, including the LRC, has opposed this bill because it disadvantages the poor woman who has to firstly walk long miles in order to get the first facility, but then being told, wait, you're going to have to wait until the ultrasound confirms that the gestation period is actually at this point. So those are some of the issues. Oh, and one of the big issues we have in South Africa is that of conscientious objection, where a medical practitioner can say, for religious reasons, they will not perform a termination of pregnancy. Now, in theory, this is supposed to mean that they will refer you to another practitioner who can perform the termination. But in most cases, this does not happen. The doctor simply says, I do not perform this, and this is where it ends. So in our submission, also to access to information, we would like to know which protocols are in place so that we then use that very same information to say, okay, these are the practices that are theoretically here. In practice, then, how does this relate to women's daily lived experiences? And as the LRC, we are putting forward submissions to the National Department of Health, as well as also just going on campaigns in order to inform women of their rights and hopefully have more information as to where they can have their terminations in a safe place, in a safe environment, and eventually reduce the stigma around terminations of pregnancy. Thank you so much.
Thank you very much, Bongiwe. I think that's very useful to hear that even where progressive law is passed, as the South African law is, that there may still be such massive practical difficulties with access to abortion. So that's really useful for us to hear. Our next speaker is from the other side of the world, from Colombia. That's Nina Chaparro, and she's working with Dejusticia. Dejusticia? You say it so much better. Thank you.
No worries.
She's a researcher in the gender area, undertaking research and litigation on sexual and reproductive rights, and is published in the area. Nina, do you wish to speak from there or from here?
Here.
Okay,
I feel
great.
comfortable here.
Thank you.
Thank you. Good morning, everyone. I'm very glad to be here. Thank you for inviting me in this crucial moment in Ireland. So I'm a human rights lawyer. My name is Nina Chaparro. I work in an NGO, human rights NGO called Dejusticia in Colombia. And, okay, I'm going to start. This is a general context of the voluntary termination of pregnancy in Colombia. 11 years ago, Colombia partially decriminalized abortion. In its decision 355 of 2006, the Constitutional Court determined that the criminalization of abortion was unconstitutional in 3 cases: when pregnancy is the result of rape or incest, when the pregnancy endangers the life or health of the woman, including mental and emotional health, and fetal malformation incompatible with life. Although the Constitutional Court's role was indispensable in taking this important step, behind the court's decision is the story of a feminist social movement that fought to obtain this right for more than 30 years. This process was a feminist bottom-up process. During the 70s, feminist movements made some attempts to decriminalize abortion through legislation and began a discussion about the freedom of women to make decisions regarding their bodies and motherhood. During the 80s and 90s, the women's social movement held its first national meeting and women's NGOs began to emerge. In this decade, women's movements framed abortion as a public health problem and as a threat to the lives of women, in particular the poorest. In 2003, feminist organizations created an interdisciplinary group of experts to formulate strategies in favor of the decriminalization of abortion through the Constitutional Court instead of the Congress, Parliament. In 2004, the program director of the organization Women's Link Worldwide, Monica Roa, challenged the constitutionality of the article in the Criminal Code that criminalized abortion, and at the same time, other women's organizations supported the challenge through amicus briefs and initiated a communication strategy to give national and international visibility to the issue of abortion. As a result, abortion became a national public debate with constant demonstrations and public debate in the media. Finally, on May 10, 2006, 11 years ago, the Constitutional Court of Colombia, in a court decision that represents a milestone in the struggle to build a more just society for women, recognized that legal and safe abortion in 3 circumstances forms part of women's sexual and reproductive rights. 11 years after the court decision, we are evaluating its effects to see whether the right to abortion exists in practice. Data regarding abortion in Colombia vary according to the reporting institution. According to the Colombian Ministry of Health and Social Protection, 4,638 abortions were performed in 2015, while the Ministry of Health of the city of Bogota, capital city, reported 13,790 abortions in the same year, so different numbers. Additionally, the Guttmacher Institute conducted a study in 2008, which determined that for that year, 4,400,000 abortions were performed in Colombia, of which only 322, the 0.08%, were reported as legal procedures. So we are not using the system at all. Thus, the Colombian health system does not have complete information regarding abortion. We don't know exactly how many legal or illegal abortions are performed. This lack of data perpetuates the negative image of abortion, prevents its normalization, and encourages arguments contrary to the rights of women and couples. Despite the lack of information, many organizations like Dejusticia have been doing research regarding the obstacles to accessing abortion. We have identified at least 3 types of obstacles. The first is the lack of understanding of normative issues regarding abortions. As I said, abortion is mainly regulated by constitutional court jurisprudence, not legislation. Through 9 cases, the court has defined the cases in which abortion is legal, access requirements, state obligations to guarantee the right to abortion, and the rights of women, amongst others. Despite this, Parliament has not passed a law that codifies this jurisprudence and simplifies its application in practice. The lack of regulatory basis for legal abortion has created 2 problems. First, in practice, this means the rules for abortion are scattered across at least 9 constitutional court decisions. This makes application complex and time-consuming for health officials and providers who need to extract these rules for their particular practice. For example, most health officials don't know that the court has determined that a woman requesting to terminate a pregnancy that is the result of rape must only provide the copy of the criminal complaint and may not be required to provide any additional information or test. Second, not all officials understand mandatory nature of constitutional jurisprudence. In practice, some providers think court orders regarding abortion are not mandatory. There is a huge confusion about this normative. The best way to address the confusion and lack of information regarding the regulation of abortion would be for Congress to adopt a law codifying and expanding upon the court's rules. However, due to political factors and strong opposition from conservatives, it appears that this will not happen in the near future. The second obstacle is the societal prejudices and opinions. In a study, Dejusticia found that abortion remains a censored topic and has negative connotations in various sectors of society. Sometimes, even when women meet the requirements to obtain a legal abortion, they refuse to go ahead with the procedure to avoid the negative opinions of the family and friends. There is also a generalized perception that all abortion practices are highly dangerous. This belief, of course, creates an obstacle to abortion access, as women are unaware of the different methods of abortion. The third obstacle is the lack of medical institutions, trained professionals, specialized knowledge, and abortion-specific models. There is a lack of clarity regarding the number and location of health institutions that provide abortion services. This lack of information means that women don't know where to go to obtain an abortion. This obstacle is exacerbated in the case of poor women in rural areas, as they do not have the economic capacity to visit several health institutions or travel to the places where they are referred. Finally, only a small number of health professionals are available to train to provide abortion services. Many health professionals don't practice or order abortion services because they lack of academic training. This is an important point. Specifically, they emphasize, doctors, that medical schools' curriculums does not include topics regarding contraceptives, sexual and reproductive rights, or abortion. Today, 11 years after the Constitutional Court's partial discrimination of abortion, the progress made is ensuring access to legal abortion has been enormous, but insufficient. As mentioned above, obstacles that prevent women from making a free, informed choice without prejudice. This situation is particularly alarming for low-income women in rural areas, as I said, where the state provides the only health services available. Colombia currently faces at least 4 challenges to ensuring access to legal abortion. I'm going to finish. Okay. 4 small challenges, at least. First, the state needs consolidated data and a clear panorama regarding abortion services in Colombia. This would allow the state to understand and reduce barriers to access through structural responses that address the causes of the barriers. Second, regulatory challenges persist. Colombia needs a specific law or decree to provide abortion services based on the protections the Constitutional Court has issued. This would make abortion procedures easier and remove doubt regarding whether they are compulsory. Finally, Colombian society must be educated about the right to abortion, the autonomy of the woman's decision, the types of safe abortion methods, and the institutions and doctors that provide abortion services. Medical schools must train students regarding abortion and how to perform there. And of course, there are more topics emerging now about the right to conscientious objection, about how to reparate or compensate women who couldn't have an abortion legal. So there are many topics emerging now, 10 years after the decision court. This is a general panorama. Okay.
Thank you so much. Thank you so much, and thank you, as with the other speakers, thank you for such a rapid but comprehensive overview. I think it's particularly interesting to hear of the problems associated with regulation of abortion through constitutional court jurisprudence rather than through legislation. That's something we may pick up on in the Q&A. So our final speaker is Judit Zeller, who's from Hungary, and like Nina, she's a human rights lawyer who works as a legal officer with the Privacy Project of the Hungarian Civil Liberties Union and specialises in human rights and healthcare. So Judith, next.
Yeah, thank you. And I've tried to speak from here because I have a presentation as well. So I would like to outline this backlash we have talked about already because it's present in Hungary. Actually, we have a 25-year-old legal framework. We have an abortion law from 1992, and it's actually a mixed model. We have indications and we have time limits. The indications are, I think, the general ones, so pregnancy is the result of rape, or there are fetal anomalies, also fetal anomalies are listed there, or if the pregnancy is a danger to the woman's life or health. And finally, we have an indication we call, or let's call it, life crisis. This indication had been criticized, of course, throughout the years, and it has been tried before the Constitutional Court also once. The time limits are, I think, also very general. The last point of abortion, time point, is actually an unlimited time. So if there is a fetal anomaly, then the pregnancy can be terminated at any point. Going to the procedural framework of the termination of pregnancy, we actually have a counseling system. If you want to have an abortion, you have to file a request, and then you have counseling in 2 sessions at the child protection services. The first session of this counseling focuses mostly on your opportunities to continue with your pregnancy. So what kind of state funding you can receive, what kind of family support you can have, or you have information on contraceptives and so on and so forth. And then, if you sustain your will to terminate your pregnancy, then after 3 days, you can go to the second session of counseling. And in this session, you are informed about the procedure of abortion itself, of the hospitals or the facilities who perform abortions, and very importantly, that you can have support from the state, actually from these family protection services, if you need a post-abortion support. There has been a recent research whether these counselings are biased or not. And there are some biases. So 1 out of 10 women experience blaming. They experience some kind of emotional pressure to continue with their pregnancies. They experience that, that these counselors are not neutral. Half of the women lack information. So they are practically, although it is, so there are legal provisions in the Act itself that they have to be informed on certain things. They are not, so they don't know anything about contraception, they don't receive any information on the facilities, they don't receive any information on the possible supports the state can give. And now I will come to these lurking restrictions in Hungary. So first of all, Hungary adopted a new constitution recently. It has been adopted in 2012. And we have a provision in the constitution that explicitly refers to the protection of unborn life. So it says that the life of the fetus shall be protected from the conception, from the point of conception. This was a proposal of the Christian Democrat Party, so one of the governing parties now in Hungary. And actually, it was interpreted by lots of people in a way that this will mean the restriction of abortion in Hungary. In the end, it turned out that the government doesn't want to change anything in the legislation. It is, however, so I would say it makes a bad impression, I think, for a lot of people, because there is a basis for abortion restriction. We can reach back to this provision of the Constitution at any time. So this can be a ground for modifying the existing acts in Hungary. Another huge problem in the legal framework in Hungary is that contraceptives are not funded by the state at all. There is no sexual education as well, I would say, so the schools do not include anything on that topic in their curricula. And abortion pill is prohibited. And this abortion pill question is quite interesting, actually. The HCLU had made an inquiry in the relevant ministry why the abortion pill is not allowed in Hungary. We didn't receive any clear answer, actually, because there were no medical reasons. So they answered that there are other compelling reasons for not introducing this to the general healthcare system. Other examples of this lurking restriction or the change of attitudes of politicians and of the government of Hungary, there is a good example. If you take a look at this poster, this had been displayed in a campaign which was supposed to promote gender mainstreaming in Hungary or gender equality in Hungary. So there was a, yeah, it's very interesting. Hungary received EU funding for to promote gender equality in the society. And in the end, they figured out that they could use this money for anti-abortion, for an anti-abortion campaign. I couldn't find it with an English translation, but so it says that, let me live at least. I know, or something like that, I know that you might not be ready for me, but let me live at least, and give me a way for adoption. So it was actually a very controversial campaign in itself as well. The good thing is that these posters had to be taken down in the end because they were not compatible with this EU funding. Another striking example of the change of the government's attitudes is that we have a national holiday at the 15th of March. It's the Springs of Nations, you know, the revolutions of 1848. So there was a demonstration on the 15th of March in Hungary, and some people, some participants were invited from Poland to Hungary, and they somehow misinterpreted this occasion, and they came to Hungary with huge posters, which were anti-abortion posters, actually, and they were displayed in this demonstration. They were quite shocking, actually, for all people who were taking part in this demonstration. Now, okay, so these are only some cases, but we have a more systematic change of attitudes, I think. So the government, so actually anti-abortion speech is still a political tool, or it's getting more and more, it's used as a political tool more and more in Hungary. The government accepts and promotes religious attitudes and gives more support to religious attitudes. And this also means money, actually. So there has been a recent case where the government gave an extra financial support for clinics which were maintained by the Catholic Church, and they received this funding because they established a clinic which was free of abortion. So they agreed to a term that they are not going to perform any abortions within their walls. Actually, we also made an inquiry in the relevant ministry what this means, or what are the details of this agreement and of this funding. We haven't received any answer yet. This is still in progress, so let's see what becomes of this in the end. There are also so-called abortion-free days. So there's a movement, and there have been, in the recent years, there have been so-called abortion-free days in Hungary. Also in state clinics, so not only in private clinics, and I think this is very controversial, and it doesn't have a positive message, actually, a positive pro-choice message, so to say. And restrictive regimes are regarded as exemplary regimes for Hungary. For example, there's been recent news on that, that Russian abortion counseling centers serve as an example for future Hungarian centers, which would be established in a similar way. And finally, I would like to mention one more thing, that population growth is still an important political issue in Hungary, and restriction of abortion is regarded as an adequate political tool to increase the population in Hungary. So, thank you for your attention.
So, thank you very much, Judith, and I loved your phrase, lurking restrictions, which I think sort of sent a somewhat chilling note to all of us, that even where you have passed progressive or liberal abortion law, that there will still be these restrictions. And I think that's a theme that's come out from all of the presentations. So I just want to thank each of our panel members again for such excellent and very tightly timed presentations about the processes leading to liberalisation and abortion reform in their countries, and their focus in particular, as we asked them, on outstanding difficulties, challenges and human rights issues that are still in existence. So we do now have about 15 minutes for questions, I think, Liam. Still, and I might ask again. We'll take maybe in groups of 3, and I might ask that everybody who raises a hand would identify yourself. Yeah, yourself first, because it's very hard to see from here. Yeah, yourself. And there's a mic going around.
Hi, my name's Sinead. Thank you so much for all the speakers. I have a specific question for Bongiwe. You mentioned that in the 13 to 20 week period there was an assessment criteria based on socioeconomic grounds. Could you tell us a little more about that, and in particular, is it the medical practitioner who's supposed to conduct that assessment? Thank you.
Okay, thanks, Sinead. Yes? Yep, Francis, is it?
Yes. Thank you all for your presentations. And this actually is both panels, but it's addressed to your panel. We've been very concerned with the backlash against human rights defenders, and particularly women's human rights defenders. And in Hungary, this is what reminded me to ask the question, we went on a country visit to Hungary, and one of the concerns was that the government was making sure that funding went to conservative women's organizations and not to progressive women's organizations. So has anybody got any comments on what's going on with women in reproductive rights in your different countries, or with women human rights defenders?
Thank you, Francis. Is there anyone else want to come in at this point? Oh, sorry. Oh, yes, yeah, sorry. Yourself, sorry.
I'd just like to address the class issue in a... Sorry.
And so your name, just...
Yeah, my name is Fiona Boyd, with People Before Profit, pro-choice. A class issue, because it's well known in Ireland that procedures have been available for the rich people in Ireland to have abortions in Ireland. And it's very much a class issue in Ireland about access to maternity care and access to abortions for socioeconomic reasons. And I'm just wondering if you're finding that in these countries as well. Is there availability for the rich, and is there does the restrictions on abortion affect people from lower incomes more than those who are rich?
Okay, thanks, Fiona. A very practical point as well. I might ask maybe Bongiwe, if you want to speak first just about that specific question, and then to address and then each panelist to address the others.
Okay. The requirement that the law says is that it is the medical practitioner who, after consulting with the pregnant woman, is of the opinion that her socio-economic condition would be, disadvantaged with the continued pregnancy. So it does not really give us a clear indication of what counts as, socio-economic, because in South Africa, many of us are living in situations where you are coming from the rural areas. And I know, for instance, that I'm originally from rural areas, township, then, progression eventually. So in most cases, you find that the poverty is seen as something that is relative. So if a doctor is of the opinion that you already still have 5 kids, but you can handle 1 more, then it will be something that they don't really take that much into account. But the law says that it's the medical practitioner who then must be of the opinion that the termination would result in a disadvantage socioeconomically. And I think I can also just touch on the question. It was one of the pushing factors for us as the LRC is to basically look at how terminations of pregnancy are affecting women in rural areas. Because in most cases, like I said before, that there's a number saying that it's 505 facilities, but we don't know where those are marketed in according to the different provinces. And in most cases, we are aware that health facilities in rural areas have very low technology. So in those situations, you do find that women will eventually go to a back street type of abortion because you do not have access. I, for one, know that there was a time when I was not on medical aid, and I'm from relatively, it's a town type of situation. So I was not on medical aid, but I needed to go see a specialist. The waiting list for that was 3 weeks. So because I'm not on medical aid, so I needed to go to public hospital. So the access is there, but the waiting list is long as well. So then you find that women are having to face those challenges where if you do know of a medical facility, you go there, you're told to come back in 3 weeks, or you are just told we don't perform terminations in this one, try find another one. So that's how it affects women. Yeah.
Okay, do you want to speak about Francis's question? On the funding, I think, of women's rights organisations.
So I didn't catch that question.
The question about...
Intimidating and funding, harassing, and lack of funding.
For the activists. No, and
harassment and lack of funding for activists, for women activists.
I don't think in South Africa there's been a lot of harassing in terms of sexual reproductive rights. So in most cases, our constitution allows for women to exercise their choice. So in most cases, the constitution will protect the activists in terms of that. And funding, it's usually civil society will, outsource or source funding for the different types of activities. So there hasn't been direct harassment based on the fact that you are lobbying for. Not that I'm aware of, let me just say. Yeah.
Okay, I'll ask each of the others in turn, maybe Claire and then Nina and then Judith. Yeah.
So in terms of the harassment, it is a real problem across the UK in certain hotspots. In Ealing in London, the council there has just decided that they're going to explore the possibility of a buffer zone outside the clinic to prevent people from picketing. Basically, they harass the women going in and out, and they have images and various other offensive things. And that's the first time that's been actually explored. Obviously, in England, abortion is readily accessible. Even in Belfast, where it's not readily accessible, people are still picketed. There's a small Mary Stopes clinic there, the Family Planning Association in Belfast, and people have to act as volunteer to be escorts, to escort the women in and out of the clinics, even when actually they're going just to explore, maybe talk about contraception, talk about like counselling, and that's not really been addressed in Northern Ireland at all. And Emma from Alliance for Choice is here, lots of members, volunteers, escorts. Some of them have been physically attacked by the protesters, so it's a real issue. The other thing, the class issue, is like totally, people have always said that women at home, like in Ireland, that women who have money get abortions, people who don't have babies, and that's hopefully the changes that I mentioned briefly, where low-income women can travel for free and access on the NHS for free will help, but still there's also another tier of women who will never be able to travel and who can be very vulnerable in different ways, either because they can't physically travel, because they have restrictions on their travel, because they have an abusive partner who forbids them from travelling. Like, there's just, it's still a big dimension, I think.
Sure. Okay, Nina?
Okay, regarding your question, we don't have statistics, but we have a huge research about this privilege to reach women, to reach women. So many women organizations are working on that, and said that abortion has been and is still a privilege for rich women who have money and also live in cities where they can go easily to a health institution. But for poor women who live in rural areas, very far away, it's very difficult. But in Colombia, it could be more difficult because we are facing, as you know, a peace process. So many rural areas were full of actors, armed actors like guerrillas or paramilitaries, so it was very difficult. Now we are facing a peace process, but it was very difficult for a woman to go to a health institution because she had to cross many barriers and get there and explain everything. So it was almost impossible for women who live in those areas in the middle of an armed conflict. So, of course, almost impossible. And those areas are also very religious, and lack of the presence of health institutions, lack of education, everything is very, very, very difficult there. So we have like two Colombias. The Colombia in the cities, like everything work kind of good, but the Colombia in the rural areas that the state is not there at all. Yeah.
Thank you. And Judith, if you want to... I think that question from Francis was specific about Hungary as well.
Yeah, actually, I would say that NGOs are harassed in general in Hungary, momentarily. So, but it's true that we had some political utterances where there were, which were humiliating or degrading for women. Also from a prime minister himself, and yeah, of course, so the role of women is very well defined in this political agenda. So in these terms, yeah, of course, they don't like women's organizations, I would say. And concerning the other question, the general rule is that abortion is not financed in Hungary, but if you lack the resources, then the Social Security finances it for you. I think the problem is what I've already mentioned in my presentation, that contraceptives are not financed at all. And that, so this means that poor people get pregnant and rich people don't get pregnant if they don't want to. And of course, the abortion pill is not available. So if you are rich enough to travel to, I don't know, Austria, because I think it's a very well-known spot where we can go to from Hungary, so in Vienna, for example. If you have enough money, then you can travel and you have a safer procedure, probably. If you don't have any money, then you stay in Hungary.
Okay, thank you. We've time for just one more short round. If there's a couple more people who would like to come in at this point and make points or comments. Yeah, yourself there.
I just wanted to thank the organizers of this conference. It's so important to hear what the backlash, what the regression looks like. I know I'm sitting from privileged Canada. We have our backlash and regressive forces as well. We've seen certain small restrictions try and make their way in. Some successfully come in with the new abortion pill. That there were particular restrictions placed on this medication that don't exist for other more complicated medications. We've seen language try to be changed in legislations, and 1/3 of our parliamentarians voted in support of referring to it had to do with sentencing of somebody who hurt a woman who was pregnant, and by doing so, there was a miscarriage. And the attempt at the amendment referred to the fetus as a baby. And that was voted down, but it was voted down 200 to 100. So there were still 100 people. And I think it's, we've always said within INCLO that the importance of the work that we do is that we know that the regressive forces and the backlash, they're working together and they're learning from each other. And I'm just very happy that we're here today and that we're able to learn from each other. So I wanted to express my appreciation.
Well said, thank you. Anyone else? Yes, yourself there.
Hi, I'm Emma Campbell from Alliance for Choice in Northern Ireland. I have a question, I guess, for everybody on the stage, which is specifically in Northern Ireland and in Ireland as well, actually. And I know Les will be talking about this later, but this idea of fatal abnormality has crept in, where it used to just be serious fetal anomaly or malformation of the fetus. And somehow the people fighting for abortion access, it's just been accepted, kind of without protest and without, and it's been kind of then been the thing that we're fighting for instead of the thing that is one of the worst restrictions. Okay. So I just wanted to know people's experience of that in their own countries.
Okay, thank you, Emma. One final point, if anyone has a last point. And sorry if somebody has a hand up. Yes, yourself. Yeah, I'll give you the last word.
Hi there, my name is Siobhan Donoghue from TFMR Ireland. Just in relation to the mention of backlash, I just wondered, and in general in campaigning in this whole area, is there one piece of advice you would each have for us campaigning here as what do you think is the best thing we can do to counteract that backlash and to improve our chances of succeeding? Have you anything that you've learned through what you've experienced in your own countries that you think could help us here?
Thank you, Siobhan, and that's a great final question. So we might leave it on that. I'll come back to each of the panel just very briefly to respond to the points raised to that particular question, Siobhan. If I might just, Emma, just deal with that point in terms of Ireland, how it refers to this jurisdiction on fatal fetal abnormality. And I know Fiona's still here as well and may want to come in on it, but my own view is that the reason we have been talking so much in Ireland, in the Republic, about fatal fetal abnormality in recent years is because of the Eighth Amendment. Like so much else, that's the effect it's had. It's because the rights to life, as you heard, of the so-called mother and so-called unborn are equated. The view has been that a view has grown up that I certainly would share, that it would be possible within the terms of the Eighth Amendment to legislate to allow for abortion where the pregnancy was going to result inevitably in the birth of a dead baby or in the fetus dying while in utero. So the idea is that if certainly I think the legal interpretation is fatal fetal abnormality might well be constitutionally permissible without any constitutional amendment. We fought for that for some time in the debates leading up to the 2013 Protection of Life Act, which you've heard about. There was a concerted attempt by quite a number of us, lawyers and politicians, to try and get that put in. Siobhan from TFMR knows about this too. The Termination for Medical Reasons group certainly were hopeful at one point that we would get change in the law. The Irish government had argued, in fact, in a bizarre move in a case some years ago before the European Court of Human Rights, that if a fatal fetal abnormality case was taken in Ireland, in the Irish courts, it would succeed under the Constitution. So that, I think, is why we have been almost pushed into a corner of using language around fatal fetal abnormality. Okay, so I don't know, I'm sorry that becomes a little bit technical, but I think that's why here, because the view is that because the fetus has this constitutionally protected right to life, if a doctor couldn't say with certainty that a fetus wouldn't survive birth, then you couldn't have abortion under the 8th Amendment. Hopefully that debate will all become irrelevant once we repeal the 8th Amendment next year. Hoping and anticipating that will happen. But and Claire may wish to say something about that language of fetal abnormality in the Northern Irish context. I don't know if Fiona wants to say anything more. Fiona de Landres on that. Yeah, thank you. Lawyers agreeing, that's a good sign. Yeah, Francis. Yeah.
Unfortunately, it's not only in the Irish constitutional context.
Okay, well that's good.
It's globally, and now you've got the reinforcement of the CLPD. So that it's being reinforced that we're being driven back to that language. And I agree with the person asking, saying that this is very restrictive language.
Thank you, Francis. Yes, I mean, I'm conscious of how restrictive it is, but the reason for it is, in Ireland, is very particular. But as you say, there's a broader context. Okay, Claire.
My answers are very short in that I defer to Emma and Les on FFA, but I know it's a term that obstetricians have tried to distance themselves from in some way. On the advice or counter backlash, I think that's really hard, but I think the contrast in what I tried to show was that you can either say, be ambitious because you might not get any more opportunities for change, which is what happened with the 67 Act. It's paused at 1967. Northern Ireland is frozen in 1861. And so while in one sense I think some campaigners might regret, and I don't mean that there's any judgment on them, the ones who campaigned for the 67 Act, that they weren't ambitious enough. If they'd have realised, we'd still be here. But at the same time, when you look at Northern Ireland, you're very much looking at the bare minimum of what you might be able to achieve, because any progress seems so far away. It's depressing, sorry.
I think in terms of advice, it would be, we as South Africa, obviously, by the time that CTOP started, we were literally coming from an apartheid system. So in most cases, even the strides that we were looking towards, we were trying to be inclusive. So even in acts such as the CTOP, you were trying to include as many women as you can, but still bearing in mind that the people who are still in power are male. And this is not in any way to bring about any type of, situations. But in most of the cases, the decisions were being made by males who were not 100% sure of what abortion would mean. So I would think that in order for it to be a success, you would need to be aggressive in, firstly, women owning the fact that I want to have an abortion done. And in as much as there will be backlash from communities and from society, because in most cases, I know in my country, the minute you say abortion, people become uncomfortable. And the usual response to that then is to retract and keep quiet. Whereas as a country, we are known as being very much, we are an aggressive country. So at a point where it is uncomfortable for people, in as much as race as anything other, when people are uncomfortable with the topic, you do not simply stop talking about the topic. You spread it out as much as you can. Start introducing it to children as well, because when children are familiar with talking about certain concepts, it then becomes less difficult for you to explain to a 12-year-old who, for instance, has been raped, that you are having an abortion, because to them it's still going to be a taboo. So the more aggressive you are, the more you explain the process in simple terms that an everyday person can understand. And I think the most important thing is, at the face of uncomfortability, carry on louder. And yeah, eventually it will get to a point where you are just bold in it and you continue and you fight for it. Thank you.
Thank you. Thank you. Nina?
Okay. In terms of advice for this moment, for the possible referendum, I just want to say that this process of referendums are full of lies. Full of lies. Like Brexit in England, and like in Colombia, we had a referendum last year and was absolutely full of lies. I was so sad because we lost the referendum because of lies. So my advice is like, don't trust the polls about possible results. Start a strategy now, and strategy not only for academic people, for the academia, but the population, that is the population who is going to vote. And normally conservative people, maybe I'm lying, maybe conservative people don't go to these spaces, don't talk about this, but they going to vote. So it's very important to talk with all the population, with creative propagandas, with creative messages, easily. Otherwise, it's going to be like Brexit or like in Colombia with our referendum about this peace process. So that's, now we are regretting about our referendum. We are saying like, why we didn't do a strong campaign, why we trust in polls, why didn't realize that we were going to lose. So that's my advice, like start now with the whole population.
Thank you. Good words of wisdom as well. Judith?
I think that the others already have said what I wanted to say. So in terms of backlash, yeah, detect it as soon as you can, I think, because we missed this opportunity in Hungary, I think. So we didn't believe that it's going to be a backlash. And it was so developed when we realized that, oh, where are we going? Then probably we didn't have a, or we do not have a way back. I hope we do, but yeah, let's see. And the other advice is that you should work together and cooperate, because just as Noah said, the other side is very well organized, I think.
Yeah, yep, that's right. Okay, well, on that note of unity, maybe we'll bring proceedings to a close. I just want to thank our speakers very much again. Claire, Bongiwe, Nina and Judith, and the interpreter Laura as well. And to thank you all very much, because it's been really, I think, really important and timely and useful for all of us from Ireland, but also for who've come here from other countries to learn from each other's experiences in what is, of course, a global campaign for women's human rights. So I just want to thank our speakers again, and I know everyone's anxious for lunch now. Liam may wish to say a few words first.
Ivana, just to thank all our panellists again on behalf of INCO and ICCL. We'll hope to start the afternoon session on time at 2 p.m. So lunch is served where you had your coffee just now, and we'll hope to see you back here at 2 o'clock.